You're listening to the greatest multifamily investment advice show. My name is Adam Ras, and now I'm talking everything multifamily for an in-depth conversation, and I will be diving deep into raising capital, deals, and underwriting process. Welcome back to the greatest multifamily advice show. Today we have Ryan Carson, an exceptional guest, real estate lawyer out of Ontario. Please help me to welcome our guest. How are you, Ryan?
I'm great. Thanks for having me, Adam.
Thanks a lot. Thanks so much to be with us on the show, and I appreciate you taking the time. So I think the first thing I would like to highlight here is the legal structure for multiple or many multifamily investors, especially the syndicators here in Canada. But we can start with preferred corporate structure for regular single family homes between different partnership agreements. So can we start with the pros and cons for the three-tier structure?
Sure. Well, yeah. So like you said, there's lots of different structures to putting, real estate investor deals together. And then, sometimes the structure is going to greatly depend on the property type, whether it's single family, multi, or even large multi or commercial. Sometimes the structure will greatly depend on some of the investors, requirements and wants possibly. And then sometimes it can change just on, different laws that apply in different jurisdictions. I mean, normally the most common structures that you would see with, real estate investors would be like a joint venture. That's one model. There's the partnership model. There can be a corporate model that you could use. And then some people are really asking a lot of questions and dealing with possibly like a general partnership, limited partnership fund now as well.
Yeah.
So those are the most common, like four or so structures we see as lawyers right now for the real estate investors, especially ones focusing on multifamily and scaling. Their portfolio, whether scaling means going to bigger projects, or whether scaling means just sticking to the same type but like multiplying how many they're doing. As far as I think your question was related to what do we think about the three-tier corporate structure?
Yeah.
Maybe just making sure everybody's on the same page of what is that. Usually, and there's this common suggestion, and now it might be changing a bit now in Ontario and Canada because of some of the changes in the tax laws over the last couple of years. I think a lot of people, they're not abandoning the three-tier structure, but they're modifying it to potentially not necessarily be three tiers anymore, but have some corporate structure, but potentially tie in other elements like family trusts and so forth. So every situation is completely different and unique. So you have to kind of take everything we're saying, today as just general information. You need to sit down and, have a proper consultation and opinion to really know what's going to be best suited for you and your situation. But generally speaking, the three-tier was three corporations. One corporation would be a parent company, which would own another corporation, which would own the actual real estate property itself and be the one that would take out the mortgage. And then on the basis that this is a property that's going to be rented or have tenants, you'd have a third corporation that could be like a property management company. So that's typically, which would be owned by the parent company as well, in most cases. So you kind of have this three-tiered, kind of like a triangle almost. You got the parent company at the top, and then you've got the management company owned by the parent company, and then we call it the nominee corp, which is the corporation that owns the property owned by the parent company. So this is the three-tier structure that you see. There's some tax benefits to doing it this way because you've got corporations able to flow revenues back up into the parent company, and then you have creative structure at that level, which is typically advised by the accountants. You can be isolating liability and risk from the different corporations to help protect assets, which is another reason people sometimes like that multi-corporate structure. So that's kind of what the three-tier structure is. Again, like I said, I think, it's probably wise to have your specific situation, reviewed and have a consultation on it, because I think at the end of the day, there has been a shift sort of in just defaulting straight to 3 corporations, because of the changes in the tax laws in Ontario and Canada, as well as there being some potentially other more favorable structures from a law and tax point of view, which I've seen a lot of investors creating corporate structure that have family trusts.
Yeah. I think because we're focusing here on the multifamily, I see a little bit confusion on the structure wise about when you're dealing with above 20 and 30 units in Canada, is when I use shareholder agreement and when I use or switch to the GPLP structure, when is actually it's an actual issue for the capital raisers to comply with the security law when you have to switch to the security law. So when is the silver line here between, okay, I'm okay with shareholder agreement on this limit, or I have to switch to security law?
Yeah, I don't know that if there's a magic number,
okay,
just like there may never be a magic number to say to people you should incorporate, right?
Yeah.
So, but I mean, some factors that I think help determine and maybe sway you to go one way versus the other would probably be based on, well, one, what is the capital need for the project, right? And then what are your capital resources available? If it's possible for you to have the project you're trying to finance or in process and acquire all completed with a very small number of investor clients, then doing a general partnership, limited partnership fund structure may not make a lot of sense, because you can probably accomplish a lot of the corporate tax and legal items that everybody will want to see just in a corporate structure, right? So if you're really fortunate and you've got some very good investors, deep pockets, that kind of thing, where you don't have a lot of investors, or maybe you only have 1 or 2, then that may be a factor that has you kind of stay more just on the single corporate structure with shareholder agreement and so forth, versus getting really into the whole GPLP structure and fund and partnership agreements and so forth, right?
Like the PPM, the private placement memorandum, and all of the associated papers with the GPLP.
Right. So that would be one thing, is if you don't need a lot of investors, then because you've got the capital resources with just 1 or 2 or a few, corporate structure, whether it's a big project or a small one, might end up making more sense. I think just what I said there, too, big or small projects, usually you don't see a lot of GPLPs on smaller projects, 100%. Right? I mean, you're typically talking about some sort of development or build, or we see them a lot, like specifically for us and our clients, a lot of people are using GPLP structures when they're acquiring like apartments, so probably 10 to 20 units sort of as a minimum. But again, it's not a hard and fast rule that that's the only factor, right? In those particular instances as well, with our clients that are using the GPLP for, at a minimum, like a 10 plus to 20 plus, unit apartment, up to like 50 to 100 units is kind of like our kind of bread and butter for our clients right now. In those cases, they're using the GPLP because of the size of the actual physical project, like the building, but they're also doing the GPLP because they don't have one investor or just 2 investors that can fund the deal, right? they need the GPLP to allow for them to creatively raise the capital from multiple sources, right? They probably have, you know, anywhere from 10 to 20 plus people investing, you know, increments of 50 to 100,000 into each of those GPs, right? So I think it's, you know, the actual number of investors that's probably, you know, somewhat a factor, as well as the size of the project, that probably play a big factor into, like, do you just do corporate, you know, structure with a shareholder agreement, or are you talking a GPLP fund? I think that the third factor too, which is pretty practical and pragmatic, is like, what's your appetite and budget here for professional fees, right? Like lawyers, accountants, etc. You know, you're going to be paying quite a bit more money to
on the GPLP.
lawyers, accountants, and other professionals to set up and coordinate the GPLP structure than you will likely on just a corporate structure with an incorporated business and then shareholder agreement.
I think that the silver line here also is complying with the Security Commission law is not an option for the investor or the syndicator. When, as you mentioned, the silver line is the number of investors and how to comply with the law.
Yeah, and I mean, technically, even with like corporates, you know, if you're selling shares just in a single corporation, so not even a GPLP, you still have to make sure that you've got exemptions for security compliance, right? Because you're still selling shares there, right?
Yeah.
Because they're probably giving you money in exchange for shares, so they've acquired an investment, right? In the corporate structure, and you'd be using this likely the same
structure
exemption of accredited. Like typically it's the accredited investor exemption that most people are relying upon to not have to make sure they're doing filing and compliance and becoming regulated by the Security Exchange and Commission for Ontario, right?
I think this is part you need to focus on, because not many people know this, which is basically the difference between the accredited investor and qualified investors. So I'm going to leave it to you.
Well, I to be honest with you, I don't actually practice in security law. So I always will say to investors, you know, we can do the structuring and the contracts for, you know, all of this kind of stuff that we're talking about. But we always recommend people to a separate securities lawyer, because just like tax and tax advice, we don't give the tax advice either, because it's just such a large area
100%.
unto itself. 100%. Same thing with security laws. It's quite a, you know, specific and large, you know, sub section of the law that, you know, we just usually send directly to a securities lawyer to give that advice and that distinction, and really determine, you know, is what you're doing going to then trigger obligations under a security exchange, or what you have in place and who you have investing, they qualify for exemptions. Here are the forms you need prepared so people can sign to prove they have the exemptions, and thus no further obligations or requirements under the act.
That's why we always recommend this. Not us, lawyers, of course, like you, recommend the shareholder agreement or partnership agreement, which is a corporate or a regular structure without corporate. I think this brings us to another subject, which is when you can corporate your deal, at which limit you think it's better for you to corporate and save your or protect your assets.
Yeah, I mean, at any amount, it's going to be advantageous to incorporate if you're worried about like protecting assets, because automatically, whether you have $1 or the asset's worth $1 or not, once you incorporate and once the corporation owns the asset, that's separate and apart from you as the person, right? So at law and at tax, corporations are separate, like people, persons, right?
Yeah.
So The second you incorporate, and you have assets and or debts owned or owed by the corporation, you automatically create, asset and debt protection. Like you're automatically acquiring that. It doesn't really need there to be a threshold point of value. I think what comes in the people's minds is, okay, well, if I do this incorporation, it costs X and Y for the lawyer and the accountant and the incorporation. And do I want to spend those amounts of money to get the opinions and get the corporation set up? For the value of this project, right? I think a lot of times if you're, working in multifamily spaces and you're working with investors and potentially their money, I think a really great value add that you can sort of apply and hopefully use to distinguish yourself when you're going out there to try to get investors to choose you over somebody else's project. Is if you can show them that you've got multiple structure opportunities, and depending on their situation and what might be best for their scenario, you could choose either one of these options, and either one of these options have various different, preferential tax treatments and so forth for them, right? Because they're obviously investing the money. Like most people, we're trying to get a return on our money, right, for as little risk as possible. And so if there's better ways of investing for a higher rate of return at a lower risk, anytime somebody can see that, they're going to jump on those opportunities. And sometimes one way to increase the rate of your return, other than usually with the greater risk is the greatest return. But if you're trying to, stabilize or minimize risk, but increase your investor's rate of return, sometimes that can be accomplished through just better structuring of the deal, right? So
makes sense. Yeah.
As an example, let's say it was determined having a corporation was the best way to do the deal. A question that you could pose, and one of two options you could provide to your investors is, are you going to be investing money into the corp in the sense of putting the money into the corp to buy shares, or it might be more beneficial for the investor not to necessarily invest the money and return and get in return shares. Maybe it's better for them to not invest in the company from a standpoint of shares. Maybe it's better for them to lend the corporation money. So they're actually a creditor of the corporation. They don't actually, in that case, receive shares. They have a loan agreement with the corp, but the corp is allowed to use that loan, for the purposes of what's in the documents. So that's just a very simple illustration, I hope, of two options for your investor that are very different, from a documentation standpoint and possibly a tax standpoint, which one might be greatly more beneficial
to the investor.
Not only are they going to get a rate of return, the same rate of return in each case from what the terms of the documents say, but there could be, because they're not buying shares in the one example, but they're giving a loan, there might be different tax write-offs that they can further do in the bigger picture of tax, right? So it's things like that I think are important too, to help investors as they are, trying to scale and grow and attract more clientele as investors into their projects. Because if you can show you've got more options to fit everybody's different scenarios, then you can be more creative, and potentially you're providing more and more people with a greater return and potentially some additional savings or benefits that maybe other people are just not even thinking about or considering.
I think what you said is to recap is It's just really important that the active investor has to have this aligned ahead of time to show the different structure ahead to give option to the passive investors depend on their situation to meet their needs, because everyone is different. Yeah, I agree 100%.
Absolutely.
Yeah. One of the questions is always for me, even to be honest, is sometimes I use bare trust agreement, sometimes shareholder agreement on a smaller scale, as we mentioned, like on a smaller 10 to 15 unit. So when you, in your opinion, is the best time to use a bare trust against shareholder agreement? From the tax perspective, I think, and the legal side.
Yeah, so with bare trust agreements, like usually we see people using bare trust agreements because they're trying to have title registered a particular way, but the people registered to title may or may not be like this. They won't be the sole owners of the property. They may not even be owners at all, right? And so the bare trust agreement usually denotes, who are going to be the registered holders of title as trustees for the beneficial owners, which would be the actual owners. So that's the purpose of it. And so, I mean, sometimes people consider, doing the bare trust agreement because of like financing or qualification needs, like with the mortgage or lenders. One thing to keep in mind about bare trusts, because they create, as the name suggests, a trust relationship between the trustees and the beneficial owners. The problem a lot of like banks and credit unions have is they need to have full disclosure of, are there any other third-party interests in the property, or in this case, beneficial owners and interests. And so if this hasn't been disclosed in the financing process and application process with the
lender,
the lenders, then the lawyer, if the lawyer who's doing the closing of the purchase is aware of these third-party interests or beneficial owners, the issue they run into is they have to disclose it to the bank. Right. And so now the bank might say, okay, well, we need more details, and maybe it changes or scuttles like the approval, the financing, right? So it's, if you're considering using bare trusts, you'd want to work with a mortgage rep or broker that is quite familiar with them, so that you can make sure the application for financing isn't going to be jeopardized by anything related to the bare trust agreement, right? But putting that aside, the bare trust agreement can be beneficial, as we discussed, to help set up these scenarios and situations where you want to have one person or one corporation or a group of people in a corporation registered as the title holders, but ultimately have a different group be the actual beneficial owners of the property. And so that can help with some creditor protection in a way, because it's really the beneficial owners that own this property. Just because title is owned a certain way doesn't mean they are the owner. It's just that they're registered as such. The beneficial owners are the true owners, right?
I think that also the tax is going to be on their individual's account, not on the corporation account. So the corporation is just a camouflage to the actual beneficiaries.
That's right. So there is the tax considerations that people would have to consider, because if you are noted in a trust agreement as the beneficial owner, then your accountant has to be aware of that, because they're going to have to make sure that they're disclosing that you are a beneficial owner. And then there may be taxes or other filings that are necessary to the beneficial owners, right? The other thing is, if for whatever reason, like some people like trust agreements to potentially transfer the property down the road. So maybe for whatever reason, at the time of closing, it can't be me and you on title for some reason, but you can. But you're holding it 50% for you and 50% for me as the beneficial owners. And then down the road, let's say 3 years from now, it can become you and me, because whatever was stopping it before is now, not a factor anymore. You can do that transfer of title from you to you and me with no land transfer tax, because you can do it as a trustee to beneficial owners. So that's another reason why people sometimes structure bare trusts, so that down the road there could be a subsequent transfer from the trustee to the beneficial owners, exempt from land transfer tax.
From scaling point of view, like let's say if we have an actual property in both sides, shareholder agreement or bare trust, and we need to add more investor, from legal point of view, what is easier? Is just to add more beneficiaries to the beneficiary list, or sell more shares? Let's say we want to do a value add to the property, and by doing this we need to raise more capital, and we have two types. We have the shareholder agreement where we can sell more shares, or add more beneficiaries on the bare trust. What is legal wise is more applicable and easier from the legal point of view?
I think you'd only really be able to do the shares, because if I understand what you're asking, like the bare trust agreement, if I use the example of like you're the trustee holding it in trust for you and me, but then we needed more capital for something else, and so we wanted to try to have you be the trustee and just add more beneficial owners to it. Because those beneficial owners have come after the initial acquisition and dating of the trust agreement, you might have a bit of a hard time with like just the effectiveness and legality of the bare trust, like adding people. So I would think that the better way of dealing with needing a capital raise and so forth would probably be through
selling shares,
of selling shares. That would probably be the best, but it's hard to say that would apply everywhere, because like I said, every situation is a bit unique. And all the investors are unique. Their global tax scenarios are unique. So I think you'd need a full review of each situation before you like fully applied what I've just said, because there could be another solution, that we're not talking about at this exact moment, that could be most applicable to help all the parties, maximize all their benefits.
100%. I was trying to have another subject here, is the CHMC product and the legal impact of using CHMC product on the multifamily. Is there any implication of using this product, especially that usually we use CHMC when we're doing a refinance? Is there any legal impact of using this product from legal standpoint?
Well, what are you thinking there? Like, can you provide more of an example of like when you say legal impact, like what do you mean?
When we do when we think on the beginning that, okay, we're gonna go with private lending in the beginning on the first 16 months, and then once we add value, we're gonna switch back to the CHMC product with a better returns, less interest, and so on. From structural point of view, when you're dealing with 10 to 20 units or bigger, is an actual legal structure have to be proposed to match with the CHMC requirement from the legal standards, like point of view, especially that you're going to deal with the insurance, you're going to look for a particular structure. As you mentioned, the bare trustee is an issue to disclose the actual beneficiaries. So on this point, or in this example, I don't think it's going to be the correct structure to have a bare trustee if you're looking to ensure the deal with CHMC when you go and do the refinance? This is basically my goal of the question.
Yeah. So I guess in short, I mean, again, every situation is unique and potentially different.
Yeah.
But I don't think there's a legal reason or implication why you couldn't, have the CMHC, in the scenario that you just described. Like there's no reason why you couldn't. I think whenever you're working with the banks and credit unions, as we discussed earlier, they're going to want to know if there's third-party interests or trusts or beneficial owners.
Yeah,
like they typically want to know that and have that disclosed in the application. So you really need to make sure that whoever you're working with as for the financing on the broker side, understands that and understands how that's going to work in the application. So no, I mean, there's no reason why you couldn't have a CMHC insured mortgage. I don't think, with the multifamily.
Yeah.
With the multifamily, because we have clients that, obviously acquired all these different apartment complexes, typically at first with like private financing, but are now refinancing or have already refinanced with bank insured, mortgages now,
products,
right? Yeah. So they either, have the CMHC or other insurance applicable, and the GPLP doesn't pose a problem or anything like that there. That being said, those GPLP structures are fully disclosed to the lenders, both the privates and the banks, right? So that they're all well aware of this is how the structure is and ownership and everything, right?
Yeah.
None of those particular clients have like bare trusts.
Yeah.
Like they just have the actual
Shareholder
fund and partnership agreement and so forth, right? Like in the GPLP. On other ones that elected not to have GPLP structure, on any of the closings that we do with the acquisitions or the subsequent refinances with the bank, in those cases, the clients they've disclosed there are no interests. So again, if there was an interest, they would be obligated to disclose that so that the lender's aware that there's the beneficial interest and trust component.
100%. I was trying to highlight something about you, that you're also an real estate investors. And how was the journey for you on real estate, like when you started?
Yeah, I mean, I've kind of stepped back a little bit from it because I'm spending so much. So we've had such a significant growth in our client base of real estate investors. That it's just keeping up with the work with my team of professionals here and other lawyers and so forth. That in itself has become just a lot more than it was when I first started. So I personally never got into too many like large properties and acquisitions. It was always smaller property holds and rentals and so forth. And I actually ended up selling all of those, and then predominantly now, just because it works the best for me, also wearing my lawyer hat and stuff with the work we have to do. The only real investing I'm doing right now is I kind of will do some private lending from time. So just because it's easier for me to do that, I can do not only the lender work, but I could do the lawyer work as well for myself, right?
For free.
Yeah. So that just works out to just, slide in and out easier with all the other client work we're doing. But yeah, it's been it's great. I mean, I enjoyed the journey as an investor when we were doing properties and so forth. I think a lot of the investing that I can afford to do now with my time is it's hard to do a lot of active work because I'm working with so many. We're working with so many clients, right? So many more. So a lot of what I would do is just, like I said, that private lending, which is kind of sparingly right now, or, get involved with somebody on the passive side. The problem for us is, as lawyers investing with clients, where we have heavy restrictions and regulations on them,
Yeah.
right? So it just is tricky that way, right? Like the people I'd like to real estate invest with a lot of them are my clients. So now I'm kind of conflicted from maybe investing with them unless I stop doing legal work for them, right?
Yeah,
So
yeah, yeah.
it's been an interesting journey that way, but real estate investing is obviously very fun, exciting period. I enjoy doing it and have enjoyed doing it, over the years, and I really enjoy working with real estate investors because there's like doing the real estate acquisition is exciting and it's fantastic, but there's a lot of other things the real estate investors that should be considering doing other than just buying, right? Like it's getting properly set up corporately, on the business side. It's working with you and talking with you about, what's your estate planning. You're acquiring interests and properties at potentially a very fast rate. And so I think it's important to make sure when we're talking with our investor clients, sure, we'll do your deal, right? Like we'll do the deals. But, how are you structured? Who's giving you advice on not only the deals, but your global, portfolio? And then, talking with those other advisors, finance and tax, and sort of trying to put together a good estate plan too. It's a fun, holistic opportunity working with investors. You've got deals, you've got structure, you've got planning, and so it's fun that way.
I think what one of the greatest things you're doing, basically, to be honest, is educating the public about, and like you're basically spending time to educate people. And this is one of the greatest things I like about your firm is also. But my question always I like to ask people is, what do you define your strengths or superpower?
Oh, geez. I think one thing that we try to always be to our clients, where we can, is we try to be understanding, we try to be patient, and we try to be creative problem solvers.
Yeah.
I think we've got quite a few lawyers on the team that are also investors, so they're familiar with what's happening out there in the market. Yeah. Not only are they familiar with business strategies people are taking, but they also have the legal background as well. So we're trying to, on tough cases, be as creative and as solution based as we can for people. So I guess that's, our superpower is we try to be patient. We try to work with investors, and we try to help them, make deals happen and overcome their problems, right, with solutions.
Yeah.
I would say that's it. Yeah.
That's perfect. I think one of the things always is that you're offering a lot of services, and I was trying to highlight like how the people can reach out to you and your team.
Sure. Yeah. I mean, best way to get all our contact details and see a bit more about us and just utilize some of our great resources is you can go to our website, which is www.carsonlaw.ca. And then we also have, follow us on Instagram and Facebook. We're always kind of trying to be active there, giving out information and other sessions. And our website's a great sort of starting point too, because it will direct you to different channels as well, where we've done conversations and talks and provided education on other matters. So the website's a great a great center point, but by all means, follow us on Facebook and follow us on Instagram. And if anybody ever needs anything, they can always email me, which is best, which is ryan@carsonlaw.ca.
That's perfect. Again, thank you so much for coming to the show, and we really like to bring you again to the show to talk about more structures and legal aspects.
Oh, perfect. I'd love to do it. Thanks so much.
Thank you a lot.